Hi, this is Tom. Today let's discuss one critical issue for international companies doing business with Chinese clients. When you sign contracts with Chinese enterprises, how to pick up applicable laws. Following are your starting point. 1. Priority of the law chosen by the parties. According to Article 41 of the Law on the Application of Laws for Foreign-Related Civil Relations, both parties can agree on the law applicable to the contract without the need for an actual connection to the contract. However, the following three types of contracts are exceptions. First, Sino-Foreign Joint Venture Contracts. Second, Sino-Foreign Cooperative Enterprise Contracts. Third, Sino-Foreign Cooperation in the Exploration and Development of Natural Resources Contracts. These three types of contracts must apply Chinese law. Head to Applicable rules. When no law is chosen. If no law is chosen, the law that has the closest connection to the contract shall apply. This is usually determined based on the type of contract. A. International goods sales, law of the seller's place of business. B. Real estate contracts, law of the location of the property. C. Insurance contracts, law of the location of the insurer. 3. Special restrictions. If Chinese law has mandatory provisions for foreign-related civil relations, such provisions must be directly applied. For example, contracts related to foreign invested enterprises, such as equity transfers or contracting operations, must apply Chinese law. Let's see what's consequence of incorrect choice of applicable law. 1. Obstruction of litigation procedures. An incorrect choice of law may result in the court rejecting the lawsuit or suspending the proceedings, requiring a redetermination of the applicable law. For example, in a maritime freight forwarding contract dispute, if the applicable law is not clearly specified, the court will need to review jurisdiction again. Procedural delays may increase litigation costs, as seen in a case where a payment company experienced a prolonged trial period due to unclear legal terms in a service contract dispute. 2. Increased breach of contract liability. Expansion of compensation. Scope. If an incorrect choice of law leads to a misjudgment of the breaching party's liability, they may be required to pay higher compensation. For instance, a tech company was ordered to pay excessive compensation because the calculation method for the penalty was not clearly agreed upon in the contract. 3. Risk of contract termination. In a financial loan dispute, an incorrect application of law could trigger a contract termination clause, causing the foreign party to lose its contractual rights. Recommendation: when entering into a contract, it is advisable to clearly specify the applicable law to avoid legal risks resulting from incorrect choices.